Great. So today we were joined by Robert, Brittany, and Doug of Drummond Woodsum. I want to thank all of you for donating your time for this workshop today, and I will pass it over to you to get things started.
Thank you, Rachel. Hello, everyone. We'll do some introductions, then we'll dive into our slides. So my name is Rob Liscourt. I'm an attorney in Drummond Woodsum's Business Services Group. I have a practice that focuses on various community development work and do a lot of entity formation and specifically housing development and real estate development. For background, if folks haven't heard of Drummond Woodsum, we're a firm based in Portland, Maine. We also have an office in Manchester and Laconia, New Hampshire. We're a full service firm. We do business work, employment work, all things that new startups and new businesses need. And I will pass it over to Doug to introduce himself, and then we'll dive into the slides. Doug and Brittany.
Hey, everybody. My name is Doug Ginn. I'm a shareholder here at Drummond Woodsum. I've been here since 2016. I took 1 year during the pandemic and worked at a firm in Boston, but ended up back here, which is great. I love working with local businesses here, and I do corporate mergers and acquisitions and general business advice. So, I help people with the startup process, raising money, and then hopefully lead them through an exit years down the road. And I'll also hand this off to Brittany so she can.
Thanks, Doug. Hi, everyone. I'm Brittany Mishu. I also work in the Business Services Group at Drummond Woodsum. I work a lot with Doug. So we do a lot of the same sort of things. I really like working with my business clients. It's really exciting to see, especially startups, kind of where they start and what they accomplish. So really looking forward to speaking with you all today.
Thanks, Brittany. So I'm going to share my screen, and hopefully I don't have the telltale technical difficulties that are common with Zoom. Can everybody see my screen okay? Awesome. So the focus of our presentation today, as Rachel said, please put questions in the chat as we go along. The way we structured this is we kind of build off of each other. So it makes sense if you have a question in the first part of this to ask it, because I'm sure other people have the same question, and it would be good to clarify if there's anything that we can extrapolate on. So today we're going to be focusing on the very initial investments that you might be thinking about taking on, probably from people you know, or people who've been interested and excited about your business. We've introduced ourselves, so going into kind of the outline of what you can expect for today, we're going to first answer that question about what does it mean to take an equity investment, and talk about the different types of investments that you can take, debt versus equity, and then some hybrid options, and go over the pros and cons of each. And then we'll talk about what you should consider when you're taking on an investment and what that means for what type of entity you set up, and some of the investment considerations you should keep in mind as you go forward. And then the question that we focus on a lot is kind of what is legal and what is not. Aspects of the presentation are going to be kind of logistical and practical, but then aspects of it are just making sure you're aware of what you need to comply with as you're thinking about taking on money. And then lastly, what can you do on your own, and what should you consult with a professional about? And try to end with some tips on what you should have in mind when you first call a lawyer to kind of be efficient with that time and that relationship. So with that as an introduction, I will say this is informational. Everybody's business is a little different. Every equity or investment that you're thinking of taking is a little different. There's similarities, and we're going to kind of cover the overview. But as you're thinking about your questions, keep in mind that if it's specific to your business, we'll probably ask to talk to you afterwards or separately, giving you more specific advice. But if you just have general questions, please ask them. But just keep this in mind as we go forward, that this is really meant to be a general overview, and we want to make sure everybody gets appropriate individualized guidance for your own situation and the nature of your business. So with that, I'm going to pass it to Doug for the first section on what does it mean to take an equity investment.
Thank you, Rob. So we're going to discuss equity and describe it. And I think the best way to do that is juxtaposing it against other forms of capital raises, namely debt. But there's some other interesting ways people raise money. We'll cover those as well. Rob, we can go to the next one. So what is equity? What is debt? And what's the difference? Debt, at the most basic level, is just the right to be repaid principal plus interest on the terms specified in a note or loan agreement. Now, often, especially when you're raising from family and friends, there might not be a written instrument. Hopefully there is, but you know, in the real world, that's just not often the case. And frankly, if you've got a loan from mom or dad and it's not written down, it's not the end of the world. But that's debt. And then equity, is financial ownership rights, which will grant you sometimes governing and control rights, and it'll give the owner of the equity the right to participate in profits and increases in the enterprise value of the business as that business grows. Next one, Rob. So there's a number of differences between equity and debt, and I'll cover equity and then talk about debt and then try to compare the two of them a little bit. But equity is generally going to have higher upside. If you're going to invest for X% of a company, and if that company becomes worth $1 billion, you're going to be set for life. And meanwhile, if you put the same amount of money in as a debt instrument, you're just going to get interest, and you're not going to see that huge upside. Equity is going to almost always give you some governance rights, especially at the family friend level. You're going to at least have an expectation that you'd have a right to vote the ownership percentage that you have. Depending on the level of the investment, you may have more or less governance rights. And if someone is drafting documents, you may actually invest and get no voting rights. But generally speaking, at the family friend level, you'll usually see that you get some sort of say. Equity is dilutable, so you could take an investment from mom and dad, and they get 20% of the company for $10,000, but then the company's doing great, and a year later you take $100,000 from an angel investor, and that investor gets 30%, and that 10% is now reduced to a lower ownership percentage. And equity is a much more long-term and uncertain investment. When you put money into a company, you have no right to get that money back in any set timetable. So there's no fixed obligations, and when that money's in, you're basically making a bet that this company is going to succeed. You'll receive distributions from its operations, and eventually when the company exits, there's a sale, you'll receive some sort of payment there as well. Debt, on the other hand, is very certain compared to equity. You are giving money to a company, and you will be paid back. You have an absolute right to repayment at some date, at maturity date, and you also have a right to interest. And so, whereas equity, there's higher upside, debt, there's less downside. If the company's not doing well and it has to liquidate, sell off its assets, and goes out of business, the people that get paid back first are the debt holders ahead of any kind of equity holder. Debt's also securitizable, meaning that you can, if you invest into a company, you can say, I want my investment backed by your assets, so that if the company runs out of money and they still owe you, the company can sell those assets and make you whole. So debt has less upside, but it has also less downside. And debt is generally speaking less kind of, well, it depends, but I would say debt can be less burdensome from a governance right. Usually, especially in the family friend stage, debt's not going to be tied to a lot of veto rights or control rights by the lender. So if you receive a loan from a family or friend, typically the expectation is that they'll be paid back, but they're not going to have a say in the business. Rob, we can go to the next one. So aside from debt and equity, there's convertible equity or convertible debt, which is a hybrid, and it's kind of the best of both worlds for investors. This is debt that is issued as a convertible promissory note, and it will convert into equity. sometimes at a discount, meaning if you invest $100,000, when there's a raise, you might get a 20% discount on that $100,000. So that money essentially that amount that's owed is turned into equity at a discounted price. So you're buying $100,000 equity, but at a 20% discount. And typically you can convert either at discretion of the note holder, the debt holder, or at the company's discretion, or more typically based on certain events, either the next raise of equity or the maturity of, obviously the maturity of the note itself. And yeah, that it's a great instrument, especially for investors, because they have the protection of debt if it doesn't work out, but they also have the upside of equity. If the business is doing well, they can convert and then maximize their upside. Aside from convertible notes, there's a new, relatively new instrument that's been used a lot lately. It's gained a lot of popularity coming out of Silicon Valley, and they're called safes. These act a lot like convertible notes, but they're simple agreements for future equity, and they're not technically debt. So it's just a contract right that will give investors a right to convert an amount that they gave to a business in exchange for equity upon an occurrence of an event. The big difference between that and a convertible note is that there is no maturity date and there's no interest, which is a great relief to business owners. So the biggest drawback to debt for a business owner is that you've got a maturity date looming, which is going to, eventually you're going to have to pay everything back. And that can really be a burden on the company. And you also have interest accruing on that principal. That is not always the case, frankly, in reality. When there's a loan from mom or dad, for instance, you often see, I'll work with very small businesses and they'll say, yeah, I've got a loan from my parents for $50,000. And I'll ask, well, what's the interest rate and when does it become due? And there's no answer. And that is, it's technically not right, but at the same time, it's pretty low risk when you're taking money from a close relative and it's debt like that. I don't know if there are any questions at this point, but those are the four kind of major vehicles that you see when you're investing, and definitely when you're taking investments, and definitely when you're at this early stage, it's almost always straight debt or equity, or sometimes convertible equity, convertible debt if the business owners kind of know what they're doing and have experience in this area.
I just had a quick question. I'm sorry.
Sure.
On the discount under the on the hybrid, the discount, would that be, so if somebody gave you $100,000 debt note and that was convertible into equity at the discount, would that be like they only have $80,000 in equity?
It's the other way around. So
Okay.
typically the way you would see it is, it's tough to kind of describe how these discounts work without seeing it on paper. But basically, say you take $100,000 in debt, and there's often the discount would be 20%. So 80%, the equity would cost 80% of what it costs everyone else. So there's that $100,000 debt. And then the company's doing fine. There's some interest in taking on more investment, and you have essentially you decide to raise, say, $200,000 in exchange for 20% of the company. So that would be $1 million valuation of the company. That $100,000 could be converted at a lower value, at an $800,000 valuation of the company. So it's for the benefit of the investors usually. Now, not all convertible debt has that discount, and as a business owner, if you can find people that are interested in investing without giving them a discount, I highly recommend it. And at the early family friend stage, you'll find that you're not engaging with sharks, and you will generally be able to dictate the terms. So if you want to go with convertible note, I think that's a perfectly fine option. It's investor friendly, but I wouldn't start with any kind of discounts.
Okay, thank you.
I'll quickly recap with some pros and cons, but I think I've gone over these already. But equity is less burdensome on a startup business because there's no absolute right to repayment, no fixed obligations that you have to meet in the near future. It also has higher upside, which is great for investors, because if they have a lot of belief in you, then they're gonna be really motivated to see this business grow. On the flip side, that investment is going to be, if it was worth $50,000 and you could have paid it off with debt at 50,000 plus interest, but instead your company becomes a $1 billion company. Well, now you're going to be paying this person millions of dollars for their investment. The cons are, you may be giving up more control and oversight, especially at the beginning, because, as I mentioned, typically there's not a lot of strings attached in the early stages when you take on debt, and people might expect if they're going to own 20% of a business that they get certain veto or membership rights. Another con that's not on here is that I do think it's a little bit more expensive as far as administratively and legally when you're taking on equity, because really you should have an attorney if you're going to have a business partner in general, and that attorney will need to draft organizational documents that dictate how this partnership will work. Whereas if it's debt and you do bring in an attorney, really it's a note that might be secured or not. And if you don't bring in an attorney, there's less risk really if there's no note, because it's just, there's less of an issue. At the end of the day, you owe that money back. Whereas if there's some sort of business divorce, because you're not getting along with your investors, that can get kind of expensive if there's not good documentation beforehand.
Doug, Rob, I think you were about to say the same thing. There's a good question in the chat.
Go for it, Brittany.
You can answer, Doug. Rihanna asked about
Oh, I see it.
Yeah.
Okay. All right, I'll read it out loud for everyone, and then I'll answer it. For an equity investment, when you say the investor would get a distribution, would that be expected yearly or an agreed upon interval? Also, this is assuming there's a profit, correct? Yes. So, yeah, distributions. You would again, this is why you'd want to draft something rather than just take on an investment with no language or expectations. But if you have an attorney drafting for you, generally speaking, especially at the very early stage, there's going to be no expectation of a yearly distribution. Now, later on, you might be taking on equity investment that gives certain preferential rights that, if not require you, would really motivate you to be distributing yearly or quarterly. But in the beginning, no. When family and friends are investing in you, they should have no expectation that they're going to be receiving distributions at any kind of set interval. And this would only be profit. If a company's not profitable, there's nothing to distribute. I can also quickly expand on SAFE. Caitlin, do you have any specific questions? I'm happy to discuss them more, but if there's a question you want me to answer, I think that might be a more direct kind of way for me to handle it.
My notes aren't very clear. I put simple agreement for future equity, no maturity date, no debt. So how does that work?
So safes are, again, they're really quite new, and they're not equity or debt. They are an agreement. Basically, a company will pay you, the business owner. Say, well, we'll use $50,000 as an example. $50,000 in exchange, you will both sign a SAFE, the simple agreement for future equity, which kind of, it looks both the way it's drafted and reads similarly to a convertible note. But and by that I mean a convertible note. The expectation is that you will convert this at when there's an event that requires conversion, usually a subsequent equity raise. So a SAFE will have a conversion trigger, and it'll trigger usually at a discount again. But unlike a note, there's no maturity date and there's no interest that you need to pay or be worried about. So it's just a little bit less burdensome on the business owner. I think if I'm an investor side, I would never accept the SAFE. They're not as good as either equity or debt if you're an investor. But if you're a business owner and you can get people to accept these, which I have definitely seen. I did a lot of work in the cannabis industry, and SAFEs were really popular in that industry because there were certain ownership issues, legal regulatory issues as to who could own a business. And a SAFE, you could invest in a business without owning it. So I have seen it used early, and I've seen it more often that really young companies and startups are going to these. I would just recommend that you make sure, if you're using a SAFE, don't just download one from the internet and hand it out. You should definitely have an attorney look at it and go through it. Any other questions with respect to debt versus equity or equity specifically? Because we're going to move more towards, what equity will look like and how you want to form your businesses with the expectation that you're going to be raising equity down the line. All right, well then I'm going to hand this off to Brittany.
No, I got this section, I think.
I'm handing this off to Rob.
All right. So the next section we want to cover is, what do you need to think about when you're taking on and thinking about taking an investment? And I think the question for you to think about really apply to both debt and equity, but thinking specifically about equity today. So we'll return to these a couple times, but I think there's kind of business factors for you that are kind of broad and really about your goals. And so we break those down into two categories. And so what does my company need now? Is it specific funding for a project? Is it relatively short term? You're just looking for general operating money to help you expand your business. And then thinking about what you're going to need in the future. What are my goals for expansion, and what might that possibly look like going forward? The investor specific factors, I think that really ties into the laws and regulations you need to comply with, which Brittany is going to talk about in the next section. But you can kind of think it does relate here too as well about, how many investors are we talking about? Is it just one or two people that are interested? Is it a group of family and friends? How long are people thinking or expecting to leave the money in? And then lastly, what's their financial footing, which really gets to the regulatory piece. And so the first thing we want to cover and kind of go back on, which I'm sure some of this you've seen or read materials on or seen presentations about, is we do want to talk about the types of entities that get set up and what that means for an equity investment. Because really, at this early stage, you're really talking about this initial investment is moving from a single person effort, your effort of bringing your business forward. And now you're talking about, when you're talking about equity and ownership, it's really talking about bringing on business partners. And that really, the way you do that is in the form of you're forming an entity of some type, and we're going to go over the common forms, and then giving rights and thinking about what rights your new business partners are going to have as a part of that. And it's questions when you're coming into entities. Big picture, we're looking at questions of controlling the business that you're running, and how much say do you give your investors, and how does the entity structure impact that? And then questions of profit and distributions and the things that Doug was just talking about. So I'm going to go through the common form of entities, and we're going to talk generally about them and try to tie it into the equity conversation. So the most common, which probably most of you have heard of, is a limited liability company. So that's an entity that's formed under state law. The term for owners in a LLC are typically members. And the rights and obligations of those members, the state law is very flexible. So you have a lot of discretion to set up managing members, investor members, and kind of dictate who has the right to say what about how the business is run, and then what profits and how distributions are made. The LLC is really flexible. That's part of the reason why it's so common, and you'll see a lot of people pushing towards it, is because it offers kind of maximum flexibility as you're thinking about how to set up the management of your business, and then how you give ownership rights, and then return on equity for the investors that you're thinking about bringing on. It really gives you a lot, again, just a lot of flexibility that typically LLCs, the default is that it's pass-through taxation. So income and losses are treated as income of the members. So you have an LLC and you already have members, that you're going to have a tax return. It's going to be reflected on your personal tax return. You can have the option to tax it as a corporation. This is not a taxation session, but those are things to keep in mind, and they do impact how you take on investments and thinking about it. LLCs, there's no limit to the number of members that you admit and the rights that they have. So you can have LLCs with multiple groups of members with different rights, more than 2 groups, not just investors and business owners or managers. You could have even more categories on top of that. So that's why lawyers are a big fan of it. It gives them a lot of flexibility. And it all comes down to what's in the LLC agreement or the operating agreement and defining that. And so you can have a detailed conversation about your goals with an attorney, and they can help you craft something that really meets your goals and what your investors are expecting. The other common form are corporations. They're also state law entities formed through articles of incorporation. The common term for owners in a corporation are shareholders or stockholders. I'm sure you've heard that terminology. And they can be managed either by directors of the company or the shareholders of the company directly. There's 2 forms of corporation that kind of impact how you think about equity investment. So I want to spend a little time on them. So a C Corp income and losses are taxed at the corporate level. So this is, you've heard the term maybe corporate double taxation. This is where the corporation gets taxed itself, and then any distributions are taxed as income to the owners of the company. Whereas an S Corp, it has pass-through taxation. So there's not the corporate tax, but it's passed through to the members or the owners of the company on both income and losses. So spend a little more time on that. So this, in a C Corp, you have the ability to issue different classes and types of shares and stock. Why that matters for your equity investments and for the people you're bringing on is it allows you as the founder to have certain shares or classes of stock that tied to you as a founder that give you certain control and voting rights, and issue a different class of stock to your investors that maybe doesn't give up as much management and control of your business, but allows you to raise the equity that you need. And there's no limit in the number of shareholders that you bring in. Theoretically, you just have to make sure all your legal documentation matches and gives you the approval to issue the shares and ownership that you're interested in. In contrast, I know probably many of you, if you've talked to accountants, you might be encouraged to form an S Corp for a small business. And that can impact the types of equity and funding you can do, because in an S Corp, there's only one class of stock that's permitted. So the ability to issue different classes of stock that give different management and control rights versus profit rights, you're more limited. Everybody has to have the same rights as an owner in the company. There probably at this stage, we're not thinking about this, but there's a limit to 100 shareholders or owners in the company. And then I think critically, as you look ahead to the next 2 presentations that hopefully you can tune into, is the shareholders have to be individuals or certain types of trust. So as you're looking to take on an investment from a fund or an angel investor or a more institutional investor, they're entities that would invest in you and take ownership stake. They wouldn't be able to take ownership stake in an S Corp. So move on. So the other types of entities, which aren't quite as common, but we certainly see, are partnership types of entities. And a partnership broadly is just when two or more people come together in a common enterprise. That's kind of just the term for it. But the 2 most common ones you'll see are limited partnerships, which are also formed under state law. And a limited partnership has 2 types of yeah, go ahead.
Sorry to interrupt you, but I want to answer Sarah's.
Oh yeah, no, please do.
Question comes in. So a lot of business owners today are sole proprietors, and what is the role of equity for a sole proprietor? Well, once you take on equity, you're no longer going to be a sole proprietor. By virtue of taking on equity, you're giving ownership to someone else. And so that it's just by, you're no longer a sole proprietorship, you're going to be a partnership of some sort. Now, if you're an LLC, now you'll be members. If it's a corporation, now there'll be two shareholders. But there are, so often you might have a business and it's not either, and it might be nothing as far as incorporated, and to take on equity, you're going to need to become one of these. Generally speaking, what you often see at the earliest stages is an LLC, which Rob's been over, or people often are kind of directed towards S corps, which we're trying to say, there's a lot of good advantages to S corps, tax purposes for really small companies, but they are kind of handcuffed when it comes to taking equity later. Does that answer your question, Sarah?
Yes, thank you.
No problem. I will shut back up and hand this back.
Yeah, no, really good question. A really important starting point, which should have started with. So the other types of entities that you could consider are limited partnerships, where it's a limited partnership is owned by the partners, and there's a differentiation between what is called a general partner and a limited partner. And the general partner is the one who manages the day-to-day and manages the company's business. And the limited partners are really primarily coming in as investors. It's governed by a partnership agreement. All these entities have their form of agreement. And the limited partners, the benefit of that to them is they can contribute equity without management responsibility or liability. A lot of what you can do, as I was saying with LLCs, in terms of having a managing member and then an investor member, you can get to this similar place with a limited liability company. And there's some things with partnerships in terms of there's a lot more that's dictated by the state statute, the state law on partnerships that you have to be aware of as you're thinking about forming a limited partnership, and same with limited liability partnerships. So limited liability partnerships also formed under state law, and it just doesn't have that general partner and limited partner distinction. All the partners join and come on as equal footing, and the limited liability is going to the point that they have limited liability for all the partners that are involved, and the rights and obligations of those partners to both manage and profits is going to be set out in a partnership agreement. So just to back up, because I'm thinking about it, as we think about these entities overall, I just want to make sure that practically kind of we're explaining appropriately, and Doug and Brittany can chime in too, is that for all of these entities, as we were getting at in response to Sarah's question, there's going to be, and it's appropriate to have company operating agreements, corporate bylaws, limited partnership agreements, which will lay out the rights and obligations of the people who own an interest in the company. So the people who have equity in the company, the people who manage the company, what their rights and obligations are. And so in that event, any changes that you're going to have to make setting this up, it's appropriate to consult with somebody about what makes sense for the specific situation and the ownership that you're taking on. Doug, do you want to chime in?
Yeah, I think there's just one basic point that as attorneys we neglected to discuss because we just don't think about it. But these entities that Rob is describing are all limit the liability of the owners, and what that means is if there are debts that are owed or damages that people, if your business gets sued, for instance, the plaintiff can't come after you personally if your business is run correctly, and they go after the business assets, but your personal assets are safe. Now, if you're a sole proprietorship, the risk is that you're not draped by this limited liability, and people could go after your personal assets if you're a sole proprietor. And if you took on investment as a sole proprietor and did not form any of these entities, what you would become is a general partnership, which is a really old school idea that no one forms anymore. But a general partnership would be two people that are running a business together, both of whom will be liable for any of the business's debts. So So really, these entities are designed to protect your personal assets and interests at the most basic level.
Yeah, thanks, Doug. So thinking about all of these, and one of the things that you're kind of weighing when you're thinking about taking on an initial investment and setting up one of these companies is also what is it going to look like going forward. So I think it's helpful to keep in mind that, so in a limited liability company, most of the changes are primarily in just changes to the limited liability company agreement, which you would have drafted with help from a lawyer, or and can adjust to meet your needs in a really appropriate way. Corporations and both limited partnerships or the partnership entities do require more filings with the Secretary of State to make sure that you've authorized the right number of shares, the right type of shares. The other thing with corporations is it can be administratively burdensome and costly if you've made an S Corp election, if you're taking on future investment at another stage from say a larger investor where the S Corp election doesn't make sense. So it's worth weighing that critically as you're thinking about setting up your company and taking on that first investment. And then just briefly, we did want to touch on the state of incorporation. So I think generally most of the businesses we work with, a lot of them incorporate in Maine. They do very well. They're able to expand and grow. And some of the things you'll read about the extra tax benefits of Delaware are really overstated. And so just to say that, in Maine, the Secretary of State's office is very responsive. You don't have to pay an out-of-state agent to be your registered agent. So all companies that are registered have to have somebody who can receive documents and paperwork in the state, and you can serve that role, or somebody local can serve that role. And if you're doing business in Maine anyway, you're going to have to register in Maine. So why would Delaware come up? It's really going to be in the context of the next two presentations you have, most likely, where you may be taking on money from a larger investor. The interest in Delaware is Delaware has been a business-friendly state for years, and so that the business courts there have dealt with a lot of the issues. So there's a lot of clarity that your investors have in knowing how things are going to be treated when interpreting corporate law in the context of a dispute if it comes up. And so that's a very common reason why people do turn to Delaware. So you may see some large investors who as they come in at a later stage in your business who are interested in that. That's kind of where that comes up. All right. Any questions? Oh, Nicole has a question. Can you move from a C Corp to an S Corp and vice versa? Doug, do you want to jump in on the logistics of that?
Yeah, that's a good question and a complicated one. But short answer is moving to a C Corp to an S Corp is quite easy, and there's not really any issues there. But moving out of a S Corp is quite difficult, and you'll need a lawyer and an accountant to get you through that without being impacted by kind of adverse tax consequences. So that's my issue with S Corps is when I'm working, I never try to steer my clients towards them, but again, I think there's really good reason to form them for tax purposes. And the issue is just when you're growing, at some point you're going to have to abandon the S Corp. And when you do, it's going to be legally a little bit more expensive to do that in a way that doesn't sting you. But moving from a C Corp to an S Corp, I believe, is pretty straightforward. If you are an LLC and your accountant is advised that so an LLC can be taxed as a partnership, as a C Corp, or as an S Corp. Or as if just a pure sole proprietorship, and it's only owned by one person. But so your accountant is advised that you're taxed as an S Corp, then you're an LLC that's taxed as an S Corp, which means those restrictions on S Corp apply to your LLC, making your LLC a little bit less flexible. Again, it's not the end of the world. And your accountant had probably very good reason to direct you to do this. But at some point, again, as you're growing, you'll probably encounter a place where you'll want to move out of that.
Yeah. Oh, yeah. Yeah, you would definitely know. Yeah, they would. You'd be agreeing to it if you're signing it too. Okay, so just to wrap up in this section too, just revisiting, I think the biggest takeaway is that the entity forms really, and what makes most sense for you is going to be impacted by your goals and what you're looking for now and what you're looking for in the future. And to reiterate, LLCs offer the most flexibility, and that's why they're so common and preferred, because they can really give you what you need as you grow and can adapt as you grow. And so then the investor specific factors really come up, and this is, I'll pass it to Brittany here in terms of thinking about the investors you have is going to implicate regulatory concerns and issues that you should be aware of. So I am going to pass it to Brittany now.
Thanks, Rob. So once you have your entity formed and you have your business plan in place and you're operating and you've reached the phase where you're ready to start raising capital, some securities laws under both federal and state are going to start to come into play. It will come as no surprise to you that as attorneys, we would always recommend that you have an attorney helping you through this, particularly with respect to compliance and ensuring that you're complying with all of the federal and state securities laws. So anywhere you sell securities, in any state where you sell securities, that state securities laws are going to apply. So that's going to be anywhere an investor lives. So if you're selling to investors in Maine and New York, then you'll want to be concerned with federal law as well as New York and Maine state laws. So this stuff can get pretty complicated when it comes to securities laws. If you have questions, please don't hesitate to ask. I'm going to talk about it at a very broad level. So just jump in if something isn't clear. So the general rule is that under federal securities laws, a company can't sell securities unless the offering has been publicly registered with the SEC or an exemption from registration is available. So I'm going to discuss some of the most common exemptions, some of which I'm certain you've heard of at this point. So the first one is it's under a law known as Rule 504, which is for limited offerings that are not exceeding 10 million. This exemption would be available to most companies with certain exceptions, and the offering has to be conducted within a 12-month period. Rule 506B is private placements, which is the most common exemption that we use for our clients. This is the best exemption to rely on for several reasons, mostly because it's the most risk averse, and it's the one that we would recommend for most of our clients. Of course, it's going to depend on the specifics of each company and in the circumstances, the types of investors, all of those things are going to have an effect on which exemption is going to be best for you. But generally speaking, the clients that we have most commonly use the private placement. And I'm going to talk more about the private placement exemption in just a minute. The general solicitation, the exemption for general solicitations is exactly what it sounds like. It allows companies to raise an unlimited amount of capital by broadly soliciting investors who meet certain wealth thresholds or have certain professional credentials. So this is aimed at for when you're selling your company to the public rather than to people that you know. The last one is the newest exemption under securities laws. It's referred to as crowdfunding. I'm sure you're all familiar with GoFundMe and Kickstarter. Those types of equity raises are relying on the regulation crowdfunding exemption. So this is usually geared towards companies who are collecting small amounts of investments from a large number of people. It allows you to solicit investments from the public. So this is generally people that you don't know. There are certain limits on how much you can raise. You can only raise up to 5 million. And you have to do it on an SEC registered intermediary. So GoFundMe and Kickstarter are all registered intermediaries, and they take care of most of the regulatory piece, which includes providing information to investors and making them aware of certain things. We don't typically recommend crowdfunding to our clients if there's another exemption that they would fall under, because crowdfunding is not the safest way to raise capitals. It leaves a company open to a lot of liability because you're selling to people who are not considered under the law as sophisticated investors. And so they could potentially sue and say that you didn't comply with an exemption, which would, if they won, it would allow them to get their purchase back. I'm going to go to the next slide unless people have questions about that.
Question, on the crowdfunding, I mean, where you have a bunch of different investors giving small amounts of money, I mean, in exchange for, I mean, I've seen smaller companies do it for, spring bonds at the greenhouse or whatever, you know what I mean? What is given in exchange for, a $15 investment?
It's still an ownership in the company.
Yeah, okay.
Yeah. So it's not always, Doug, did you want to say something?
Well, yeah, I just think that those are kind of two different things. You're talking about like if Nicole, the example you were using was, basically buying some sort of kind of participation, right, in a local market or something.
Right. I guess the two are different, right?
Yeah, those are different. That's more like a sales benefit. That you're not getting any equity. I don't think people would consider that as a security, but that is regulated by the SEC.
Gotcha. Thank you.
No, that was a good question. So I should probably just explain that securities laws are also a type of anti-fraud law where they're intended to protect your investors, from making investments in fraudulent companies or based on misleading statements. So the federal government wants to protect investors from giving their money without any information or, based on fraudulent statements. So if you don't meet all of the conditions of an exemption, purchasers or investors may be able to return their securities and obtain a refund on the purchase price. So obviously that's worst case scenario, but that's why we would suggest having an attorney, at least review with you the type of investments that you're considering to make sure you're either subject to or not securities laws, and then to make sure you're in compliance with them. So going back to private placements are sales of securities to a known group of private investors rather than to the public on the open market. So this is known as a safe harbor under Regulation D. Both private and public companies use this exemption. Startups, large companies rely on private placements to raise capital from investors. Hedge funds and other private funds also use the private placement exemption, and it's a really useful means to grow and expand your business. You can go to the next slide, Rob. Thanks. So not to get too into the weeds on the securities laws, but just generally speaking, private placements have, of course, certain requirements that the offering or the sale of securities has to meet to fit into the exemption. So companies can raise an unlimited amount of money, but they cannot publicly solicit or advertise. So these have to be to folks that you know or companies that you know. You can sell up to 35 non-accredited investors and an unlimited number of accredited investors. The word accredited investor is a defined term under securities law, and I'll get into that onto the next slide, but it's sort of what it sounds like. So an accredited investor, you can think of as a company or individual that is more of a sophisticated entity or person, someone that is wealthier and can withstand potentially a total loss of their investment. Companies that sell to non-accredited investors are required to disclose additional information about the company than they would if they were selling to an accredited investor. Non-accredited investors you're required to provide them certain financial information, and you need to be available to answer just any sort of questions that the investor might have. Investors also cannot constitute as a bad actor. That's also a term under securities laws. It's a person is considered a bad actor if they have certain criminal convictions that that fall under the regulation. So when we're doing investments for our clients, we're asking the investors to represent to the companies certain things. Some of the most important things we ask an investor to represent to the company is that they are accredited or non-accredited, and that they're not a bad actor. And this protects the company from a suit down the line, where somebody could say they weren't following the securities laws. And one reminder to people, and I think this is something that is a common misconception, is that securities sold in private placements and under other exemptions are considered restricted securities, which means that investors cannot freely resell or otherwise transfer the securities once they purchase it. So once they make an investment, they can't just sell it to their mom, if they feel like it's becoming a risky investment and they can't afford it, something financially burdensome happens to them in their life and they want to get that money back, they really can't. You can go to the next slide, Rob. Thanks. So just a bit more about accredited investors. This is the definition under the law, so you can read it on your own time, but limiting the offering to investors who are considered accredited helps to ensure that the investors are financially sophisticated and able to afford the risk of loss, including the potential of a total loss of the investment. So individuals and companies are considered accredited if they meet certain threshold wealth requirements. So for example, individuals who earn an income over $200,000 for 2 years in a row, and then are expected to have that same income in the current year, can be considered unaccredited. If the person has a net worth over 1 million, and that's there are certain requirements in the calculation of a person's net worth. I think your residence is not included in your net worth and certain things like that. And then certain people who kind of work in the industry, like brokers and other financial professionals, banks, those are all considered accredited investors. So those are the safest people to invest to, although some of the most the most difficult investors to find when, especially if you're just kind of getting into this and you're a startup. You can go to the next slide, Rob, thanks. So just a little bit about, oh, I should stop. Does anybody have questions?
I think, so this is all pretty technical, but the reason for it, even at this early of a stage, is that if you are looking to take investment from a lot of people, and by a lot, I mean really more than 3 or 4, and they are not family members, we would push that we can keep these in mind at all times. Now, if you're taking money from mom and dad and it's debt, then don't worry about this. But if your business is at that point when you're looking, I need $200,000 and I know mom, dad, and their friends can help me with this, then those, when you start thinking about people that you know, but you're not super connected with, you really need to be considering, are these accredited investors? If they're not accredited investors, I might be in this gray area of whether or not this is a private placement or if this is potentially subject to SEC regulation. Now, if you're thinking about, I've got one friend who's going to invest X amount of money, then you're really moving away from an investment and more about talking about a partnership with someone, of 1 or 2 people that are bringing in the money. I view that more as you are forming a business together. You might be the founder, but that initial money is the formation of the business. Beyond that, once you start thinking about taking on money from a broader scope of people, you really need to start considering these kind of complicated regulations, and that's when you want to jump to an attorney ASAP. And even when you're forming a business with 3 people, you should be working with an attorney to make sure that we form appropriate organizational documents and everyone understands who's in control and how that works.
Doug, I think the next 2 slides kind of touch on the issue of when, but I think the examples are really helpful. So Sarah just sent one to me that I think maybe is for us to address. And so if you have somebody who's producing food and they're looking to move out of a home kitchen, so they're looking for say a $50,000 initial investment, and they have a professional contact in the food industry who might be interested in investing, how would you think about that in the context of when to consult with an attorney and what should they be thinking about as they?
So this is a professional relationship that you're talking about?
Yeah.
Then you'll definitely you should have an attorney negotiating on your behalf. And it sounds like in this instance, it's either a company where that person would have ownership, or there might be some sort of joint venture. But if the relationship is not a personal one, then you definitely want to have someone on your side negotiating your side of it. And even if it is a personal one, again, just because there's a lot of navigation when it comes to how this business is going to be run and what we can expect with respect to distributions and other issues, that's where you're going to want to have an attorney advising you. I'd say the difference is when it's 2 or 3 people coming together, or like you said, my friend's got money and they want to put it into my business, you're kind of working with both of them. But when you're working across from someone else who's in the industry and is looking to work with you, then that person, they're not an adversary by any means, but you need to be considering the relationship specifically with your client and how this relationship might affect the relationship with this professional contact.
So I think, so just to build off of what Doug's saying and speak about it in general terms. So I think when you're thinking about taking on money, we've already heard that folks are consulting with their accountants about what sort of elections to make. So we kind of see the 2 groups of professionals in 2 categories. So tax and business consequences of equity and debt. Think about talking with an accountant, other business decisions. That's where an accountant can be helpful. And then where a lawyer can be helpful is how to set up, as we talked about in the entity section, how to set up the equity investment and set up the company that you're forming with these other people that want to invest and believe in what you're doing, so that it still remains your company and it operates in the way that you intended and you founded it. Thinking ahead to future growth on the choice of entity and investor rights, and then strictly, really important to keep in mind the securities law compliance. It's not something that all attorneys think of, and that's why it's something we want to touch on because it's something for you to at least be asking about once you start going into a broader group of more people. And then to revisit what Doug said too, you know, if we're talking about a note from a family member or some, you know, a one-off individual loan, then that may be something you can get away with not having at least costly legal counsel involved with, but you might want to talk to somebody to memorialize it.
And I think so. My brother's in the restaurant industry, and I think it's a good example of this, where it's a small business that often gets kind of funded by the community. Someone knows a chef, someone that's interested in opening a business, and they get a group of people together, and they all know each other, they're all friends, and they form this business. Like, that is where the securities laws actually matter a lot. It might only be $150,000 that you're raising, which isn't necessarily a lot, but even so, you need to start considering, well, are these people accredited? If not, like, what if, because restaurants go under more often than not. And if that happens, you don't want to be sued by your neighbor for the money back, even though the business is already gone and there's no money to give except money coming out of your wallet. So it is important to have this in mind at the outset, just because it's those things that you're not thinking of that can really get you.
So just circling back with a little bit of time, then we can open up to other questions and examples. So just revisiting the factors here. So this is when you're thinking about meeting with your lawyer and your accountant too, but with your lawyer, it kind of goes back to those business factors. You know your business better than anybody, but really running through some of these questions or questions that kind of get at these same themes and being ready to address them with your attorney can be really helpful. So the company factors, what do you need now? And what do you need in the future? And then the investor factors, which really get at it, will help an attorney be able to evaluate whether there's a securities law concern or something more that you have to do given what your goals are and the scope of what you're thinking about. So I think that's where we have it. That's kind of, we're coming up on our last slides here in terms of a summary, but I think given the time we have left, we can stop screen sharing and go to questions if people have other questions or follow up or things that we didn't address that you're wondering about, examples that we can think about. Please let us know.
I have a question. In terms of, so if you're thinking of starting a business, and let's say you would need probably, I don't know, let's just use 100,000. And somebody came to you, friend or family member, with kind of an unsolicited offer. Like, I always think of just traditional, I got to go to the bank and get a loan and do all of that. But how would you handle, I mean, how would you even begin to start crafting, if they say, well, I've got, I'll give you the 100,000, and, you ask them, well, what are you thinking of? And they don't have any idea. How do you even go about crafting an offering for that?
So that, I think there's a distinction between having a company that you've started and then looking to raise money, and what you're talking about, which is coming together to form a company. And what you should do is the two of you should talk to, and if you need the advice, some people just know what they want to do, and that's great. But if you're looking for guidance, an attorney can help you discuss, like, well, what's the expectation? They're giving you the cash, but you're going to be running the day-to-day, and attorneys can be really helpful at walking you through how that can go. But I view that not so much as an equity raise as a business formation question. Like that's capital going into a business, but you guys are forming that together. One person might be more responsible for the day-to-day, but that's let's form a business together, which I just, in my own mind, I view that a little bit differently than a business that's selling securities to raise money.
How about that same question, but someone's a year in? So they've been running their business for a year. They need $100,000 investment to grow. There's someone in their network who wants to help out. That person maybe doesn't live in Maine. They don't want anything to do with the day-to-day running of the business.
It's still similar. I still view that as, well, you've got one company and now when you bring in one big major partner like that, you're really doing that together. Although if you've been running the business for a year, I would recommend that you find an attorney and you speak with that person, and then the attorney is going to represent you in the business. But that is definitely very common, and it is I would view it as an equity raise, but it's very much a private placement where you don't need to worry about the regs that Brittany was talking about. That, because it's just one person. When it's one person who approaches you or that that is almost always going to fall into a private place. You don't need to worry about it. It's when you start expanding to multiple individuals that you need to be concerned about it. But something like that, let's find out how to run a business together. You as potentially as the silent partner and me as the person that runs the day-to-day. What that negotiation would involve is, well, what kind of say does that person have? Obviously, they wouldn't have day-to-day say, they wouldn't expect to, but they would probably expect to have some veto rights and maybe some participation rights. If you're going to look for more money, you have to go to them first, along those lines. But that would be the conversation that you'd be having with that individual.
Yeah, and I would think just asking questions about the expectations too. I feel like sometimes when I've talked to clients about what they're thinking, and not everything has to be fully baked when you come to talk to a lawyer, but having some base, okay, you're investing this much. What does that mean for you in terms of what are you looking for now, in a year, in 5 years, and in 10 years, and just kind of playing that out a little bit. It doesn't have to be in legal terms, but it certainly is helpful to have an idea of what that person's expectation is. And before you agree to it, to have that conversation with a lawyer about before you start giving up rights in your company or taking on debt, whatever it looks like. So. Any other questions or comments?
I was just thinking this personal connection, I'm thinking I would want them to have no say in the business.
And you could so you could have them. I mean, the amount of say that you want to give someone is up to you. Generally, when we're talking about one big silent partner, what you often see is a number of veto rights. They also, depending on what their expertise is and whatnot, they might have an advisor position, and where they're not a director per se, but they would be kind of privy to what's going on and be able to give you some insight. And then the other thing to consider is just, what is the next step? If you're taking this person on, what is their expectation and what is your expectation? Are you going to continue to grow? Because you need to be considerate of how much equity you can give away. And if they're talking about giving you a debt, like, well, we might need more money in the future, are you going to be willing to subordinate that debt to a bank later on? So there's a number of considerations, but I think it's better that a person that is a silent investor have some say, because it's just going to keep them involved, and I think people work better that way.
Doug, you've mentioned veto rights a couple of times. Can you just explain what that means in the context of a really small company?
I will. Sorry for sometimes I get ahead of myself here. So veto rights with a really small company would be is with respect to major decisions. So in a really small company, a major decision might be selling the business or raising new money, taking on new money and new partners. If there's only 2 of you, maybe that second person wants to have a say as to whether or not we're going to invite 5 more people to be part of the business. Taking on debt or putting a lien on any of the assets. Those might be some of the major decisions that you would be talking about at that early stage, or changing the business. Like someone invests in your trinket making business, and then you decide that actually you want it to be a marketing company. Well, that wasn't what they expected. So they would hopefully they would expect that, the investment they're investing in is the business that they were investing in. Any other questions that we can answer? Well, Sarah and Rachel, I mean, if we're about 15 minutes early, but if no one has any other questions, I don't think we need to keep everyone here.
Of course, yeah, I agree. Thank you. I will say, I want to share with everyone that this is the first part of a 3-part series on equity investments. So I'm putting 2 links in the chat now. You have to register separately for the other 2 parts, so you can check out those links now. And I will share those in a follow-up email as well. Rob will send me the slides that he shared today, so I'll send that out along with the recording, so you can refer to this presentation at a future date. Again, I want to send a huge shout out and thank you to Rob, Brittany, and Doug for donating their time today for this workshop and sharing all of that information. I hope you found this helpful, and I want to thank you all for joining us today.
Thank you, everyone.
Thanks,
Thank you
everyone.
so much for tuning in.
Thank you.
Take care.
Thank you all. Have a good one.